Hey everybody, it is November of 2021, and as always at this time of year we have a brand new Lincoln Douglas resolution to take us through the end of the calendar year, and that is resolved: a just government ought to recognize an unconditional right of workers to strike. If you're like us, you may be, fingers crossed, about to go to an actual in-person debate tournament. We did that at Middle Tennessee State last weekend. It was great. We got second overall, won the team debate division. Pikachu was there. We sang the entire first act of Hamilton on the car ride. There were paper postings on the wall. Haven't seen those in a year and a half. So it was a great time. For me as a longtime debate coach, it almost like brought a tear to my eye. So may you all have the experience of returning to in-person debates soon. But whether you do or not, whether you're debating in person or online or some combination of the two, we have a really impressive, somewhat intimidating topic to cover. And as always, we want to pack a lot of useful information into the time that we have. So as always, the timestamps and the links to citations are going to be in the notes below. If it is helpful, maybe like, maybe subscribe, maybe tell a friend. And of course, you can always follow us on Twitter at Hail State Debate for our general musings on life and debate in general. So we've got a lot of things to cover. Let's jump right into the initial thoughts. First, let's start with the good. This is a great general topic area. To be an educated person, you need to understand how labor and collective bargaining rights work. They have been integral to structuring economies and societies around the world over the last century. It's also very timely, as unions and labor strikes seem to have been sort of dormant in the United States, or felt that way over the last couple of decades, and to have been less influential globally. But in the last few years, as COVID has taken hold, we have seen a resurgence in union activity and strikes as workers are pushing for more leverage and better wages and working conditions. So that's the good. The less good would be the wording of the topic, the specific wording. I'm not crazy about it. And mainly what I'm talking about here is the specific term unconditional right. There are some other things I'm worried about, but that's the main thing. The term unconditional right really, I think, puts the AF in a little bit of a tough spot because, as we're going to talk about later, there's a strong argument that there's really no such thing as an unconditional right to anything. All rights have conditions. So the AF almost has to get into a little bit of a definitional fight at the very beginning of the round to show that an unconditional right in this context has some more limited meaning than literally no limitations on a right. And this is made even more difficult by the fact that in the real world, in terms of what like governments actually recognize and what scholars actually advocate for, almost nobody recognizes or advocates for a truly unconditional right to strike. In other words, one with no limitations whatsoever. So there's not a lot of mainstream literature for that. So you really are going to have to be careful as the AF about how you define what your burden is. And we'll certainly talk about that. Now, on a closely related note, this is a topic where definitions in general matter a lot, not just unconditional right, but phrases like a just government and several others. There are at least, I think, 3 potentially important definitional issues on the resolution, and none of them have obvious right answers. So there's a lot of potential for like definitional fights and topicality fights and fights about burdens, right? And we'll talk about what those are later. But suffice it to say, this is ideally not what we want to be doing in a debate round. But if you know that there are potential definitional issues at the outset, you can be prepared and save yourself some headaches, or maybe have potentially some major advantages by being better prepared. Lastly, I would say that you need to be sensitive to the fact that we are talking about something that is of great personal importance to many people, to their livelihoods, and also to their dignity. Sometimes when we do topics that touch on, for example, like nationality or race or gender, we remind students to be like very aware and sensitive to the language that they use for obvious reasons. We tell you that, to many people, this is not some abstract debate topic to win a trophy on. You're talking about who they are and their culture and their identity. Well, here, we're going to be talking about issues related to like economic class, like working class versus management, like the holders of capital. And these are things that really matter on a practical level to a lot of working people in the world. Union membership, the dignity of work, the fight for fair treatment. These aren't just abstract concepts to working class folks around the world, right? So just keep that in mind as you debate, particularly, if you're walking into the round in a nice suit and a relatively new laptop. Be aware of how important these issues are, and do not be dismissive or glib on anything, but certainly not on this resolution. So with that, we'll go ahead and jump into the substance first with a discussion of some historical and economic background, followed by definitions and framework. Then we will move on to the AF arguments, then the neg arguments, and then final thoughts. Okay, so we're going to start with a quick look at the historical and legal background on the topic. It's a lot to cover, and I'm going to try to keep it relatively brief. Specifically, I'm going to be leaving out a lot of history on things like major strikes, a lot of major legislation, and there are several reasons. First, it's because there just isn't time, and secondly, it's partly because I think a lot of the important details are going to be covered effectively in like the definition and substantive argument parts of the video. But it's also partly because trying to cover the labor history and labor law of a particular country like the United States really takes too narrow a focus. This is a resolution about labor strikes on a general global level, so it makes sense to learn about the broad concepts and ideas, not so much to learn about like the Pullman strike of 1894. And I say this as somebody who was a practicing labor and employment attorney before becoming a university administrator and debate coach. So it really pains me to do that, but I think it's necessary. Now, to be clear, I'm definitely going to be referring to U.S. laws on things like the National Labor Relations Act as examples and illustrations because they're very important, right? But I'd actually encourage you to try not to rely too heavily on U.S. legal sources unless it is, for example, to provide a specific illustration of a more general point. So with that, let's get started with the most basic question: what is a labor strike? Well, a solid answer comes from the Encyclopedia Britannica, which is good because it's, again, not just one country's law, but a general global definition. So it says that a strike is a collective refusal by employees to work under the conditions required by employers. They can arise for a lot of reasons, like economic conditions to get better wages and benefits, unfair labor practices, to protest, illegal things your employer is doing against workers, sympathy strikes, jurisdictional strikes, and of course there are illegal types of strikes, which is going to be really important later when we talk about what the conditions on strikes are, like sit-down strikes, wildcat strikes by workers who are not approved by the union. In other words, going out on their own and striking without union approval. And we'll talk more about what the contours of what a strike means as the video goes on, but just note that what we're talking here is a collective refusal to work, not by just one person, as a means of leverage, right? To use it as bargaining leverage to try to improve wages or working conditions, or to otherwise address some injustice or violation related to labor. That's what it is. Also note that in the status quos we'll talk about extensively, whether a strike is legally protected depends heavily on questions like why it happened, how it happened, who was involved, and other details. So as we're going to talk about at length, really the core of the affirmative advocacy on this is going to be that what we have right now in terms of a right to strike is this very complicated, limited, qualified, conditional right with lots of exceptions and limitations. And we're going to say it should be much simpler, much broader, much easier to understand, and much more robust, right, in order for it to be useful to make the lives of workers better, right? So the next question is, what is a strike for? Well, we've already sort of answered that, right? It's a form of bargaining leverage. But to really understand it, you need to have a basic comprehension of what collective bargaining is and why it's necessary. So collective bargaining is the idea that individual workers, in many cases, tend to have very little bargaining power against large employers. So, say you're living in a small town in Pennsylvania where most of the jobs are at the steel mill, or maybe you live in rural India and there's a large factory farm run by like a big company or something, right? You walk in and you apply for a job. You ask how much do they pay. They give you some really low number you can barely live on. Well, classic free market economics would say, well, you can bargain with them. You can withhold the thing you're selling to them, which is your labor, until you get a price or a wage or working conditions or whatever that you want, right? But that idea of bargaining on equal status to get a fair deal might work for two companies negotiating like a contract with each other, but it doesn't really work for individual laborers, does it, right? If you say to the company, if you say to the steel mill, right, well, I need more money to feed my family. I've been a good, reliable worker for you for years. I want a 20% raise, or I'm just going to have to quit. Well, they can say to you, no, thanks. We can just let you go. There's tons of people who want these jobs. We can hire the next applicant for the same amount of money that we pay you and not have to pay a raise, right? They know you need a job more than they need you as a particular worker, and that you may have relatively few options, given your skill set. They have thousands of options, you don't, so they have all the leverage, and they can easily walk away from the table and you can't, right? It's not always like this, right? Certain skilled workers may have considerable leverage because they have like rare in-demand skills, like a software engineer from Stanford or something. But for many workers around the world, particularly those who have skills that might be easier to replace, it is essentially impossible to meaningfully bargain with an employer because they hold all the cards. They're just in a much more powerful position. So collective bargaining is just the idea that to even out the playing field, workers need to be able to bargain together, collectively, right, as opposed to individually. And this is where the general idea of labor unions come in, right? An individual says, I'll walk away from this job. The company says, fine, we'll get somebody else. A union representing all or most or all of the company's workers says, hey, we'll all walk away. You can't replace us all, or it would be very difficult. It will take you months or years. Well, then the company has to sit up and listen and more likely respond to the demands, right? So why do we give unions this special right to bargain collectively when we don't give it to, other people and other industries and things like that? Well, the idea is that, and this is pretty intuitive, right? But big businesses and corporations are obviously very powerful in our society. And generally speaking, they aren't taking into account all of society's interests. They're mainly concerned about their own profits, right? On a secondary level, they're concerned about giving their customers what the customers want in order to make profits. And in most cases, they have no incentive to be concerned about other stakeholders, specifically about their workers, right? Generally speaking, a company has a strong economic incentive to pay its workers as little as possible, work them as hard as possible, unless it's somehow forced not to, right? So we give labor unions this special ability to bargain collectively to balance out the scales, right? To force these powerful companies to have to negotiate against something that is approximately close to being as powerful as they are, at least closer than an individual, right? To take into account this sort of other side of the coin of capitalism, which is the interest of the worker as opposed to just the interest of the manager and the owner and the customer, right? So that brings us back to the question, where exactly do labor strikes factor into all this stuff about labor, organized labor, and collective bargaining? Well, the strike is the most basic final weapon that a union, or in some cases just a group of workers, but usually a union, has to gain leverage in negotiations with an employer, right? To be able to bargain with someone, it's often said, to be able to meaningfully bargain, you have to be able to say no and walk away from the table, right? So employers can tell you no in lots of different ways. They can take away your job and your income by firing you. If you ask for better working conditions, if you ask for a raise, they can simply tell you, no, we're not going to do that. The way workers and their unions are able to say no, the threat that they have to back up their demands, right, is to strike, right, to take away their labor from the company, effectively shutting it down in some cases, right, by refusing to work. Now, the strike is sort of like the nuclear option, right? It is the trump card that you would rather not use. You want to try and meet and bargain with management. You hope that you can talk your way to an agreement that works for you and works for them. But you do that with both sides bargaining in the shadow of the strike, right? Having the knowledge that if an agreement isn't reached, workers can decide to walk off the job, which hurts everybody, including the employer, right? Which hopefully creates an incentive for the employer to make concessions that are beneficial to the workers. So kind of like the nuclear weapon or, any weapon really, the hope is that you will use it to negotiate to get what you want without ever actually having to use it, right? Now, strikes have been around for millennia, dating back at least to ancient Egypt, but the legal right to strike is really a product of the 20th century, right? In the United States, the National Labor Relations Act, or NLRA, of 1935 formally recognized private sector workers' right to what's called concerted action to force concessions from management. Public sector or government employees are a different story, which we'll talk about later, but whether they have the right to strike is very up in the air. It's very dependent on what jurisdiction they're in. It's not at all guaranteed for public employees. In other countries, around the same time, they did the same thing. So, for example, in France, they recognized the same right of concerted action in 1936 through the Matignon Accords, and many other countries enacted similar laws throughout the 20th century. And the main form of concerted action that happens under these laws is the strike, which leads to the question, okay, since the resolution is talking about this unconditional right to strike, is an unconditional right to strike something that most countries recognize? And the answer is absolutely not. If you think about it, the idea of an unconditional right to anything is kind of strange, right? Pretty much any right you can think of, including your most basic rights like life, liberty, and property, are conditioned on various things. So you have a right to life, right? That's the most basic right, right? But if you decide to take a gun and go attack people with it, the police can and will lawfully shoot you and end your life. Same for liberty. You break the law, you go to jail. Same for property, right? Don't pay taxes, the government will come and seize your assets. Literally every right that we have is conditional. And we'll come back to this later and talk a little bit about it in the definitions, about how AF can try to strategically define this. But for right now, suffice it to say that pretty much every country that recognizes a right to strike does so with significant conditions and limitations, right? Because remember, the right to strike is not simply the right to quit your job or walk off your job and then protest. That's a common misconception that you need to be aware of at the beginning. If that were the case, if the right to strike was simply the right to stop going to work and complain about working conditions, then the AF argument for a right to strike would really just be an argument against compulsory labor, which literally nobody disagrees with, right? But that's not what it is. Marley Weiss in 2000 has this piece that you can see here on the right to strike versus the right to permanently quit, and it explains that the right to strike is something fundamentally different. It's the right to temporarily withhold labor with the expectation of being entitled and allowed to return, right, if whether or not you achieve your goals. It is not simply quitting and walking away. So that's an important distinction, right? In the real world, under existing laws, the right to strike is more than you can just walk out and then, whatever happens, happens. That's called quitting, or that's called walking off the job. For it to be a right to strike, there has to be an expectation of some protections of the striking worker. And the basic protection you get in most cases is some right to reinstatement after the strike is over. And that is something that is recognized in the United States under the NLRA and in most other countries. The problem is that legal protection, that right to return, is contingent on a whole bunch of conditions. And this is where the resolution really starts coming into play and why we chose this specific wording of the topic. So what kind of conditions are we talking about? Well, in the U.S., the National Labor Relations Act, the NLRA, and other federal laws place conditions on when a strike is lawful or not based on things like why a strike happens, how the strike happens, who is striking, and more. And if a strike is not lawful, then your right to return after striking as a worker can be limited or in many cases non-existent. So to be able to debate an unconditional right to strike, you really have to understand what the current conditions on protected strikes are, right? The right to return and the right to continue working. How else can you argue that they're, problematic in the app or potentially justified in the negative, right? So we need to take a minute and run through a basic summary of what these conditions are. We're going to look in depth at these conditions under the NLRA in the United States specifically, but I'm also going to point out some resources for looking at other countries, which I can assure you also have somewhat similar, in some cases different, but somewhat similar conditions on the protection of striking workers. So for the NLRA, a good plain English source for what it says is the National Labor Relations Board's own website on the right to strike, which we will of course link to. Now, the first type of condition that we have in the United States, and this is common in pretty much every country, is conditions on the purpose of the strike. Section 7 of the NLRA recognizes at least 3 basic major reasons for striking that are protected. So the first is an unfair labor practice strike, where you are protesting the employer committing some kind of unfair or unlawful practice, like, say, trying to intimidate people out of joining a union, or spying on the union, or refusing to come to the table and negotiate at all. If you strike for this reason, then you do have a right to reinstatement to your job in the United States. Right? The second type of strike is an economic strike. And this is what you might think of generally when you think about striking. This is a strike to get better wages, better benefits, better working conditions. If you strike for this reason, though, you might be shocked to learn in the United States, you do not have an automatic right to reinstatement. You can be replaced with another worker. Now, you do have a right to be given preferential status for rehire if positions come open, but who knows if they're ever going to come open, right? The third type of strike is called the sympathy strike, which is when one group of workers who are not actually striking now decide to not show up to work in solidarity with other workers. In other words, to not cross the picket line is kind of the term. In here as well, just as with the economic strike, the right to return is conditional, right? You might be able to return if jobs are available, but there is no strict rule against replacing you. So right off the bat, you can see that even for types of strikes that are ostensibly protected under federal law, for 2 of the 3 basic rationales for why you might strike, you don't have a guaranteed right to get your job back. And that includes economic strikes, which is the most basic type of thing where you're trying to get better wages and benefits. Okay, so that is conditions on the purpose of the strike. Some purposes that are not protected: strikes that try to force the employer to do something illegal, right? To violate labor law. So if you strike to try to force your employer to fire all the workers who didn't join the union, well, that's illegal. You're not protected in doing that. So the negative is going to want to point to things like that and say, well, hey, obviously we should have conditions that prevent protection of striking workers when the strike is aimed at getting the employer to break the law, right? That seems pretty reasonable, doesn't it? Another example of prohibited strikes is the so-called secondary boycott strike. This is where workers at Company A strike to force Company A to stop doing business with Company B. And this is often because Company B may have a less union-friendly approach to its workers. And the idea here is that each individual employer and its workers should be able to decide between themselves through their own negotiations whether to unionize without having another company pressure them by engaging in this sort of secondary boycott strike, right? So those are some examples of illegal types of strikes, right? Now, second, in addition to conditions on the reason for a strike, in the U.S. and many countries, there are conditions on the manner in which strikes can be conducted, the things you can do in the strike. And these are pretty straightforward, right? So just to give you a few examples, sit-down strikes are not protected in the United States. This is where employees physically occupy the employer's facility but don't work. They refuse to work. Sit-ins, right? And that typically will deny the employer the ability to use their facility to try to bring in replacement workers. This is illegal, right? Because you're trespassing. It's not your property and you're blocking the employer from using their facility that they own. Strikes that physically bar or block people from entering or leaving the facility. This is not protected because it denies other people freedom of movement. It has the potential to lead to physical confrontation and violence. And that is the third, restriction on the manner of striking, the things you can do. Strikes that threaten or use violence obviously are not protected. And it should go without saying that threats or the actual use of violence against management or threats against non-striking workers, replacement workers, those are not protected under the law. So strikes that use that will not be protected. There'll be no right to return. And again, the negative is probably going to want to try to argue that that is an eminently common sense condition, right? And that even if you support a general right to strike, you have to have conditions like they can't be violent. And that should be in and of itself sufficient reason to vote for the negative, right? Third, in the United States, there are often limits on the timing of strikes. So, for example, there are things called intermittent strikes that are not lawful. These are often very short, like one-day strikes that are planned in advance to happen again and again, off and on, right? And the idea is to disrupt the employer's business repeatedly for short periods of time, right? You go on strike and then you come back so quickly that the employer doesn't have time to replace you. Right. And because the risk of being replaced is kind of recognized as like part of the give and take, it's like the risk you take when you strike, right? Well, at least under the current law. The idea that you try to dodge that, like I'll show up one day and then I'll skip another day and then I'll show up another day and then I'll strike another day, is seen as illegitimate. So that is illegal. Right. In addition, if you are striking for certain specific purposes, like renegotiating a contract, there are notice periods like 60 or 90 days that you have to give before you strike. So in some cases, if the employer and the union are trying to renegotiate a contract and the union says, you know what, we're done, we don't think we're making any progress here, you have to give them a certain amount of time before you strike so that the employer can try to make a good faith effort to come to the table and actually fix the problem with the contract. Right. And then fourth and finally, there may be conditions on the protections for striking workers depending on who is striking, right? So first of all, we talked earlier about the idea of public employees, right? So what's important is the NLRA does not protect public employees in the United States. Many states, I say many states do, a minority of states do, some countries do, and some do not, right? So right there off the bat, a huge sector of public workers like me, I'm a public employee at a public university, their protection is spotty at best, right? In addition, there's the idea of strikes by people who are just groups of employees who are not acting with the support of the union. This is what's called a wildcat strike. A wildcat strike is when like a group of employees at an employer go on strike without the authorization and support of the union or for the purposes of maybe establishing a rival union. And these aren't protected under the NLRA. And the idea is that once workers have voted to establish a union, which is how a union gets established, and decided which union they want represented in, the union should have the power to declare strikes and to negotiate, because if other employees can go kind of off on their own and do whatever they want, that actually undercuts the credibility of the union and puts it in a weaker bargaining position. And we'll talk about that later. Now, if a strike doesn't meet these conditions, the basic penalty in most cases, if you trip one of these conditions, is your right to work is not protected. You can be fired, you can be replaced, right? In some cases, it can be more draconian, like with some kind of financial penalty or fine, in some cases, criminal sanctions, right? Again, we're talking about the law of every country in the world, so you're going to find some example of other sanctions as well. But in most cases, if you trip one of these many conditions, right, the penalty you pay is that you don't have a right to return to work. And of course, for working class folks who may live from paycheck to paycheck, this is a massive, massive destructive penalty. Now, this litany of conditions is pretty much how it works in every country in the world. So looking beyond the US, the European Public Service Union has this fantastic website that summarizes the right to strike in 48 European countries. And as you'll see, if you go through and click on each one of them, every single one of them has prerequisites and conditions. Are they different? Yes. Do they vary significantly? Yes. But the basic idea is that all of them have significant conditions, right? And beyond just Europe, the UN's International Covenant on Economic, Social, and Cultural Rights, which is an agreement that has 171 member countries, well, it talks specifically about the right to strike, but what it says is that every member state out of these 171 members will protect a right to strike, quote, provided that it is exercised in conformity with the laws of the particular country. So the basic international agreement that establishes a right to strike in international law explicitly recognizes that it is, in fact, a conditional right to strike, okay? So in the status quo, just to sum up, right, a right to strike is a very heavily restricted conditional right to collectively withhold labor as leverage in disputes with your employer, with a general right to return to work, but that right is heavily contingent on not violating any of a long list of conditions. So that is a quick rundown of the very, very basic aspects of labor relations and strikes. I wish we had more time to go into the history. As you can see, we just don't. We're at 20 minutes just talking about the basics. So now it's time to move on and talk a little bit about definitions and framing. Okay, so let's do some definitions, framework, criteria, stuff like that. This is where we're going to wrestle with some of the messiness and how the topic is worded. Frankly, I wish we didn't have to. I'm going to try to keep it as succinct as possible. I do not like, as a judge, debates that obsess over definitions and ground, but it's just something we're going to have to do. So let's push on through, and hopefully you can be prepared for potential definitional fights, win them decisively if you need to, and get the round back to the substance and then win on that, right? So first is the phrase "a just government." Now, the basic question here is going to be whether, because the resolution uses the article "a," that means the AF can just pick one government that they like and run some narrow advocacy that is limited to just like one country. Or alternatively, does the AF have to run a case advocating for like a general rule that is applicable to all governments? I don't know how much this really matters strategically, because I'm not sure the decision calculus on the universal right to strike is too much different depending on which country you're in. I don't know, for example, that there's one particular country where a universal right to strike is just much more justifiable than others, or where the counter arguments don't apply. It doesn't seem that way, but you never know. And if you have some kid who comes in and insists that we're only going to be debating about strikes in South Korea or only in the Netherlands because that's the just country that they picked, well, you want to be able to hit back. So let's just address that quickly. Let's run through the linguistic interpretation arguments on what the phrase "a just government" means. The term "a just government" is what we sometimes call in linguistics an indefinite singular, which just means it is the indefinite article "a" followed by a singular noun. Here it's a noun phrase. It's just government, right? Now, normally in English, when we have this formulation, it refers to one single example of whatever the noun is. So for example, if I say I work at a university, or my dogs are a Great Pyrenees and a Labrador, I am talking about one university, one Great Pyrenees, and one Labrador, right? But that's not always the correct interpretation, particularly in sentences that express normative statements like rules and laws or debate resolutions. So for example, if I say a bicycle has two wheels, I am not making a statement about one particular bicycle or even some bicycles. I am making a categorical statement about the nature of bicycles. I'm really stating a rule. You could really rephrase what I'm saying as, if something is a bicycle, that means it has two wheels, right? This is what we would call the generic interpretation of an indefinite singular, if you want to get technical, because it treats the sentence as a generic rule. Now, under this interpretation, when we say a just government recognizes a given right, what we're really saying is, if you want to be characterized as a just government, you must recognize this right, which is basically another way of saying all just governments will recognize this right, since presumably we all want to be just, right? And frankly, while there are no absolute black and white rules about indefinite singulars or really any, grammatical rule, this is almost certainly the better interpretation of the resolution. First, because resolutions by their nature are normative statements about the world generally. They are not descriptive statements like I work at a university, right? Second, because a non-generic interpretation here is just kind of ridiculous. We just don't see debates in real world literature about what one unidentified government, right, ought to do. If they meant to say a particular government, they would have named a government. They did not mean to. If they're trying to be like real world debates, they're not going to say just pick whatever government you want, right? And third, it's arguably unfair to let the affirmative unilaterally decide the ground for debate with that level of particularity. In fact, I'd say it's manifestly unfair. So here, what I would say is if the AF argues that A means they get to pick a country and pick a government, neg should respond by saying, no, this is an indefinite singular like a bicycle has two wheels. It is stating a rule about what you have to do to be a just government, what all just governments ought to do. So a topical AF should have to apply to all countries. I wouldn't go down that road if I were an AF, but if somebody does, right? If you want to learn more about interpretation and things like indefinite singulars, as well as things like bare plurals, which we're going to be talking about in just a second, there's a great article by Ariel Cohen in the Journal of Semantics that we'll link to, that we've linked to before, so you can get more familiar and maybe even cut some cards just for like general use for your back file. So there you go. Quick lesson on how to handle indefinite singulars. So next is ought. We have the usual issue here with the term ought, which is that some people argue, ought implies a moral obligation that is separate from practical implementation. In other words, this is the affirmative trying to use the word ought to dodge arguments and criticisms about how practically we would do this. As I've said before in this channel, I'm not sure where people get this interpretation of ought from, because most folks would agree that our moral obligations are contingent upon our ability to carry them out. You cannot divorce what you're morally obligated to do from your actual ability to do it in most cases. Let me give you an example. I could make the statement, a physician ought to treat the wounded. But really, that statement would depend on the particular physician's ability to perform the treatment. If the physician is, say, a dermatologist and knows nothing about treating gunshot wounds and decides that she is actually likely to make the problem worse or kill the patient, then she, in fact, does not have a moral obligation, even though she is a physician. So this idea that moral obligations, just by using the word ought, can be divorced from practical reality is just not at all supported by something, especially not by something as flimsy as just the word ought, which we use all the time. It doesn't have any special philosophical meaning. It just doesn't. I'm sorry. Then there is recognize. So recognize in this context probably should be understood as a term of art. In other words, requiring not just an acknowledgement, but also some kind of enforcement or legal recognition, right? So if you look to the Webster definition here, you've got several choices of the word recognize. I think the third one is probably the most appropriate given the context of the resolution. Because when governments recognize something, right, that has a different, more specific meaning than when we say an individual recognizes something, right? So for example, when we say that the federal government recognizes a Native American tribe, that doesn't just mean they're saying, hey, we know that this tribe exists, right? It requires some kind of formal legal granting of status. The same is arguably true here. A government recognizes a right to strike only if it grants it some kind of legal status, some kind of protection, some kind of codification into the law. So anyway, again, I don't see a lot of ground to fight here. You're really just saying that a government should enact some kind of law, some kind of regulation, some kind of legal recognition. And that's pretty much how every country handles labor laws anyway. So there's really shouldn't be too much to worry about here. Now, the big one, of course, is the right to strike, right? This is a really important definitional fight in the round, and we obviously spent some time above talking about the basics of what this is and what it means in the real world. And as we mentioned earlier, in every country in the world, the right to strike comes as a package deal with some basic protections and some basic conditions. The basic protection is that you will generally have the right to not be fired and to return to work when the strike ends, or at least to have some preferential status in rehiring, but hopefully to return, right? The conditions are all those things we talked about under the NLRA, which have similar analogs in other countries, like, no strikes to force the employer to do illegal things, no strikes to force a boycott, no wildcat strikes, no sit-down strikes where you occupy the facility, no violence during a strike. And to be fair, the negative has a pretty strong intuitive argument here that some of these conditions are eminently reasonable and necessary. For example, if my employees go on strike and vandalize the plant or attack the replacement workers or try to force me to break the law, why in the world should I have to rehire them? And if we define an unconditional right to strike this way, as in there are literally no restrictions on why or how you strike, it is indeed a pretty radical proposal. In fact, I'm not aware of any jurisdiction that has implemented or any credible author that has actually called for a truly unconditional right to strike. In other words, no restrictions. There certainly are plenty of critics of some or many of the existing conditions, taking away certain conditions, but I just can't find anybody who explicitly says, yes, let's remove every single legal restriction on the right to strike. Maybe you can. I haven't found one so far. Which means that as the AF, you're going to have to be careful and thoughtful about how you frame the right to strike if you want to avoid rounds where you're defending some really radical out there stuff like rehiring strikers who engage in violence or engage in vandalism or things like that. I think the best option here is to try to find someone who defines the phrase unconditional right to strike as sort of a term of art, like altogether, right? And has some reasonable, defensible proposal for what that means. Remember, a term of art is a phrase where the words taken together have a different meaning than the words separately defined. And luckily, there is a pretty decent term of art definition from Jorge Andres Garcia in 2017. I'm going to call this the Garcia definition. It's in an article called The Right to Strike as a Fundamental Human Right. And what it says is the right to strike encompasses any work stoppage, however brief and limited, with a view to defending and furthering the workers' interests and rights by exerting pressure on employers, including sympathy or secondary strike in case of workers who take action in support of colleagues employed by another employer. Now, this definition is good because it lets you dodge a lot of the conditions that you don't want to have to defend as the AF. First of all, it says that a strike is simply a work stoppage, right? So any concerns about the use of violence or like blocking entry or access to the plant or blocking people from leaving the facility, you're going to say they're irrelevant because those aren't parts of a work stoppage, right? Now, you certainly can do violent or illegal things in connection with a strike, but those actions aren't intrinsic to the strike and therefore are not part of the unconditional right to strike. Right. So if the AF agrees, right, with no violence, we're saying that's not a condition on the right to strike. Nonviolence is not a condition on the right to strike. Violence was never part of the right to strike to begin with, because a strike is simply a work stoppage. So like, for example, you might have a right to vote, but if you show up at the polling place and attack people, well, that's not part of the right to vote. And so similarly, violence or breaking other laws is not part of a work stoppage. So as the AF, I don't have to in any way oppose rules against violence or general law breaking because that's not intrinsic to what a strike is, right? It also says a strike has to be done with a view to defending and furthering the workers' interest and rights. So you can argue that any collective work stoppage that has a different harmful proposal is really not a strike. So for example, later we're going to talk about strikes that unfortunately were based on like racial bias toward black workers. Well, that wouldn't be part of a strike under this definition because the objective wasn't defending the striking workers' interest. It was opposing the inclusion of, for example, black workers or immigrant workers or something like that. Also, it doesn't include any limitation on the right to reinstatement. So instead of the status quo position in the US that your right to reinstatement depends on the reason for the strike, right? A fair interpretation of the Garcia definition would be that you are entitled to reinstatement regardless of why the strike happened. That's not spelled out explicitly in Garcia, but it's something you could spell out like in an observation or maybe a plan depending on where you're debating, right? And I think at the end of the day, you would be set up pretty well on the AF so that you could advocate for a general change in the status quo with meaningful impacts that help workers without having to defend outrageous stuff, right? Now, as the negative, you can absolutely debate on this ground of requiring them to defend some outrageous stuff. If you're smart, you definitely won't concede it, right? You're going to be saying, no, look, unconditional means unconditional. It means, as the Cambridge Dictionary definition says, complete and not limited in any way. And if I can show that any limitation on the rationale, the methods, the timing of the strike, the identity of the strikers, any of that, you should be voting negative. And, even if you don't win that point, you at least want to make the AF fight for it. Make an absolute unconditional right to strike your first line argument, right? It's just a matter of like a simple definition or, 2 or 3 sentences in the case. Like, if at the end of the round you believe any restrictions on the rationale, methods, timing, or participants in a strike are justified, then the right is not unconditional. At minimum, you're going to make the AF waste a bunch of time in the first affirmative rebuttal, the 1AR, fighting it back against this framing. And it's an incredibly efficient time trade where you can do a couple of sentences to force them to spend a significant amount of time to fight back from the idea of truly having to defend an unconditional right. So the next term is of workers, and there's actually a lot going on with this phrase that you need to be conscious of. First, note that the resolution deliberately specifies that it is the right of workers, and that is important because, the right is not always conceived of as belonging exclusively to workers. Some countries treat it as being like the right of unions or collective bargaining units, but here it is the individual worker who has the right. Second, note that the word workers is not the same as the word employees. Employees are permanent workers for whom an employer has like certain ongoing responsibilities like withholding and paying taxes, in many cases in the United States, contributing to health insurance. Worker is much broader. This includes people like independent contractors known as gig workers. This can be people like Uber and Lyft drivers. They can be private tutors. They can be web consultants. They can be anything, right? But they're workers who perform on a job-to-job basis rather than being hired full-time by the employer. But employers can abuse this classification by converting workers who really, as a practical matter, are like employees, right, into so-called independent contractors in order to shirk some of their duties, right? And more importantly, many labor laws like the National Labor Relations Act explicitly exclude independent contractors from their protection. So by using the term workers, the resolution actually gives the affirmative an interesting potential angle of arguing that would benefit like gig workers. It would benefit intermittent workers and help avoid abuses of their independent contractor status, which is an interesting little wrinkle that the AF can explore. And then finally, third, there is the very common question and debate of resolution interpretation about how broadly this phrase applies. Like how many workers have to have this right in order for AF to be topical and to win, right? Well, the word workers is a bare plural, which is something we've talked about before on this channel, with no modifiers like some, most, or all. And bare plurals, are a common question. How do we interpret a plural noun with no modifier? Does it mean like 2 workers? In other words, if 2 workers have this right, does that mean the AF wins? Or does it mean some indeterminate number of workers, or does it mean all workers? And this could potentially matter a lot because whatever you think about the right to strike for workers in general, there are certain classes of workers who currently have no right to strike, like public employees in many states and countries. So maybe the AF wants to say, look, the phrase just using workers lets me pick any subset of workers that I want. So I can run a case that's limited exclusively to say public employees, right? And show that they deserve a basic right to strike, and that's all I have to do. Now, negative, on the other hand, probably wants to say, no, hold on, that is not how we interpret a bare plural. And again, this is linguistic interpretation stuff. When a bare plural is used in a normative statement about like what we should or ought to do, like a rule or a law, or in this case, a debate resolution, the most common interpretation is that it refers to all, or at least substantially all. For example, if you look at your school's handbook and it says students must be in class by 8:30 each morning, that doesn't mean that so long as 2 students are in place, everyone else can show up when they want. It means that the class of individuals known as students should have to be in place. So anyway, again, we'll drop some sources in the notes below if you want to learn more about bare plurals, but that is sort of our interpretation, which is that generally a bare plural like workers means that you're talking about all workers, but it's an argument you have to be ready to have, right? So really quickly, just moving on to values and criteria. I think if you watch the channel, you know I'm not a big fan of exotic values. I think values are basically supposed to be like the ultimate destination of the case, something that's unambiguously good. So I generally talk about things like justice and morality. I don't try to get too exotic with it. So I'm not going to spend any time on it here. As for the criteria or the standards, there are plenty of good options. For the AF, if you're looking for something more traditional that avoids like straight up utilitarianism, but still lets you use all of the economic evidence about like worker exploitation, there's always the good old Rawlsian justice approach, the idea that prioritizing benefits to the least advantaged in society is what we need to do, step behind the veil of ignorance as to our place in society, and we would rationally choose advantages to the least advantaged, right? The AF could, of course, look to various forms of utilitarianism. Let's be honest, most rounds, if we're telling the truth, really do boil down to some version of utilitarianism, or comparing the outcomes and the consequences and the benefits to human beings, as opposed to, defending some abstract concept regardless of what it does. I know a lot of folks will be interested in the idea of maybe running the capitalism critique, or the cap K, right? I would just say briefly, this channel is not super focused on that kind of argument. I really don't think that you need to run critiques of capitalism as a critique here. A critique, or a K, by definition, is an argument that asserts that we're stepping outside the world of debate. In other words, we're going outside the resolution, and we're talking about things like how this debate, or how this topic, or the words used in the resolution, or the words used by the opponent, affect the real world. Unless you're talking about the real world, you're not actually running a K, you're just running kind of an edgy argument about capitalism. So unless you're running what we call a pre-fiat argument, where we're saying, Judge, you need to vote this way because you can actually affect the real world in some way, then that's actually not a critique. So long story short, I've got to be honest with you. I think you can run all of your criticisms of capitalism here as just standard impacts, right, about the resolution. You don't have to do some funky thing where you explain how the role of the ballot, is going to people are going to read your ballot, Judge, and they're going to go out and reject capitalism. No, you can just operate within the regular parameters of normal debate and say, in the hypothetical world of fiat, recognizing this unconditional right would undercut some of the harms of capitalism, and you can make the arguments that way, right? On the negative, I would say, not a ton of interesting thoughts here. I would just say, I think, honestly, something like rule utilitarianism, like what's the best rule, because the resolution stakes out such an absolute position on this unconditional right that rule utilitarianism lets you create a comparison and say, does this absolute no conditions right to strike serve society better? Or would a different rule that maybe does allow a few basic limits, right, be preferable? Would that achieve most of the benefits with fewer costs? You could also take a stab at running something like Kant's categorical imperative. In other words, can we take the resolution as stated and make it into a general maxim that should apply in all cases? And here the negative would say the answer is no, right? Because there are plenty of cases where this total freedom to strike can be harmful, and we need instead to apply conditions to it. So Kant's categorical imperative would not be satisfied by the resolution, therefore you vote negative. And also, if you want to really try your luck, maybe some libertarian ideas, but those don't tend to go over very well in debate. So that is a lengthy discussion of the framework. Now, let's jump into the part you've all been waiting for, which is arguments on the affirmative and then the negative. Okay, let's do some AF arguments. We're going to try to move quickly through these because, again, time is our enemy on a topic this broad. But of course, all the links are below, and we will try to summarize them in the graphics on screen as best we can. So maybe if you need to pause at certain points, that might be a good use of time. Let's start with the very general and broad and kind of move gradually into the more specific on the affirmative. So first would be the idea that the right to strike is essential to bargaining for worker interests. This is from Woo-Jin Lim in the Harvard Crimson in 2019. This is an undergrad, by the way. This guy is an undergrad, but he's an undergrad at Harvard, and it's very well stated. And as you can see here, we'll just pop the quote up on the screen. It's just a nice, sort of money quote to start off any, especially sort of lay-friendly case, right? The right to strike is a right to resist oppression. Functionally, strikes provide workers with the bargaining power to drive fair and meaningful negotiations, offsetting the inherent inequalities of bargaining power in the employer-employee relationship. The right to strike is essential in preserving and winning rights. Any curtailment of this right involves the risk of weakening the very basis of collective bargaining. That's just beautiful. That's just a very succinct, easy-to-read card explaining exactly what strikes do, right? So if you need something to start the case with to explain the basic rationale for strikes, that's a really succinct way to do it. I like that a lot. Whoever that is, that young man, or I guess it's a young man, I don't know for sure. That young person is an excellent writer and has a great future in front of them. So the next is that the right to strike is unfairly limited in the status quo, right? The status quo is squelching the right to strike. Now, you could spend an entire semester in a labor law course trying to understand why current regulations and conditions on strikes are arguably insufficient to give workers real bargaining power. And that's just in the US alone, to say nothing with the rest of the world. Luckily, there is a fantastic article with a bunch of cards from Diana Reddy in the Yale Law Journal in 2021 that really lays out the case for why the current maze of rules about when strikes are and aren't protected is really not much help to workers. Now, this is a super long card. There's tons of good stuff in this article. It's definitely too long to read in its entirety in a round, particularly in a more traditional, like slower speed circuit, right? but I think it's easily the best summary of why the status quo of conditional rights is inadequate. So I'm just going to pop it up on the screen so you can see it, and you may want to pause the video and read it. But the basic message here, and I'm paraphrasing, I'm not reading, is first, the protections you get as part of a so-called right to strike under US law and in many other countries is very, very conditional, right? So for example, if you strike for higher wages, you can be replaced by non-union workers. But if you strike for unfair labor actions, then you can't be replaced. But the thing is, as a worker, you may not know, like when you make the decision to go out and walk out the door and go on strike, exactly how the strike is ultimately going to be classified by labor regulators like the NLRB, the National Labor Relations Board, which means that anytime you strike, you as a worker are like rolling the dice, right, on losing your job. You can't strike if reasons for striking are considered like too political, but it's not clear exactly where the line of too political lies. And if you're protesting your employer's involvement in something that like generally hurts working class people or hurts minorities, like racial injustice, you really never know if you have protection because the lines and the conditions are so vague and they're often decided after the fact. Second, the actions that you can use to pressure your employer during a strike are severely limited to basically neuter the ability to have any leverage. You can't use like intermittent strikes. You can't use slowdown strikes. You can't use secondary boycott strikes, all of which have, means of acquiring leverage, right? You can't strike without union approval. You can't do things that are considered disloyal to the employer. But here again, what is disloyal is fuzzy. And if you're a working person living paycheck to paycheck, the risk that your strike tactics, if they're a little bit harsh, if you throw some elbows, so to speak, right, the risk that they might be unprotected and get you fired is just so great that you're either just not going to exercise your right to strike, or you're going to exercise it in a very timid, limited way that is not going to yield any change. And all of this ties in very nicely with the core theory for the app, which is that, look, if we want working class people to have real leverage, to have real equal status with their corporate employers, we have to stop treating the right to strike like this complicated maze where you can only learn after the fact if you didn't trip one of the many different landmines and are in fact protected. We have to stop stripping away all the rougher, harsher bargaining tactics like intermittent strikes, right? Yes, a slowdown may seem rough on the employer. Yes, a sit-in may seem rough on the employer. An intermittent strike may seem like it's being a little bit manipulative and trying to make the employer's life difficult. But that's the nature of negotiation. You have to play hardball to get results. And rest assured, employers are going to play hardball with you if you're a worker. Employers can and will do absolutely everything in their power to scare employees out of unionizing, to automate their jobs, to replace them when they strike, to exploit workers' economic insecurity, knowing that they desperately need their jobs, to force them to take deals that aren't fair. So we need to stop having the right to strike being, number one, unclear, so you can't depend on it, and number two, so weak that you can't play hardball when, rest assured, the employers absolutely will. What we need is a simple, guaranteed right that applies to all strikes and protects all employees who use strike tactics that actually have some teeth, as long as they don't break general laws or engage in violence, which again, as we said earlier, is not part of the definition. So I think the Diana Reddy piece is fantastic, and I would urge you to read it in its entirety. On a related note, the right to replace workers for economic strikes turns into a weapon against workers rather than a weapon for them. This is a really nifty note from James Gray Pope in 2004 about how the right to strike is actually the polarity is reversed and it turns into a weapon against workers. And what it says is that given the vagueness and the restrictions on the right to strike under, for example, the NLRA, in most cases, especially when you're just striking for like higher wages, that gives your employer a free pass to go out and try to get rid of all of its union employees and go out and hire non-union employees, maybe even to hire workers that it knows are anti-union, right? It gives them a free opportunity to try to weaken the union rather than strengthening them. And that's what conditions do, right? The point here is just echoing what we saw in the Reddy piece, which is that if you're striking for better wages, you can be replaced. And what kind of right is that? How does that right help you get better working conditions? Hey, labor union, what's your ultimate negotiating weapon? Well, we can walk off the job. Okay, well, if you do, we'll just hire new workers who aren't in a union and maybe don't support unions, and they won't walk off the job and we'll never see you again. That's not a right. That's an illusion, right? So on a closely related point, limits on the right to strike leave low-wage, less skilled workers powerless, and an unconditional right is the only way to level the playing field. This is from Alex Gurovich in 2018. It's called The Right to Strike, A Radical View. Again, another fantastic piece. I would read this whole thing in its entirety. It's almost like a pre-written case by itself. It's obviously too long to be a debate case, but Gurevich lays out the structure, how the structure of capitalist employment leaves many lower wage workers trapped in an oppressive controlling system with no real options. And it's only consensual in a technical formalistic sense, but not really. And what he says is that like the people who are most oppressed and most controlled in the capitalist system are the ones who are also most in need of higher wages. And they are also the ones who are the easiest to replace in a system where the strike is conditional, right, and limited to certain narrow types of strikes. So Gurevich argues if you really want to address the systemic injustice of exploitative employment in a capitalist system, you have to give these workers broad rights to engage in some pretty harsh tactics against their employers because they're the ones who are A, most in need, and B, easiest to replace if we allow right for replacement. So you need to take away the right to replace and give them the ability to engage in some harsh tactics because otherwise, if they can be replaced, it's very easy economically to replace them. And again, you better believe that their employers like Walmart and Amazon are going to use every single harsh tactic in the book to squeeze as much profit out of them at as low a wage as possible if they can, right? But there are tons of cards on this in the piece from Gurevich, but the really good one is this one here, which says, low skill, high labor supply workers in sectors like service, transportation, agriculture, and basic industry are in a different situation. These workers already earn incomes not far from the poverty line. They are therefore the ones we intuitively think should have the strongest case for a right to strike. Yet, even if all the current workers walk off and respect the picket, replacements are much easier to find, train, and put to work. What this means is that the majority of workers who are relatively easy to replace often have to use some coercive tactics if they want to go on strike with some reasonable chance of success. These tactics either prevent managers from hiring replacements, right? Prevent replacements from taking struck jobs, or otherwise prevent work from getting done. In other words, for the strike right to matter for most of these people, you have to take away this possibility of getting replaced, and you have to let them use tactics with some teeth. Otherwise, it's meaningless, right? Next point, strikes are being repressed to historically low levels in the status quo, right? This is another really good source with tons of cards to cut and great background information. It's written in a pretty accessible style. It's Chris Romberg from Fordham University in 2012. It's easy for both students and judges to understand. The first thing we get is the idea that strikes are declining rapidly. So as you can see here, the number of strikes in the United States is going down dramatically over the last few decades. We've seen a little bit of a spike in the last year or so, but the argument would be that's really more because workers are, for example, post-COVID, workers have an alternative, which is to accept, significantly enhanced government benefits, at least for a while, as an alternative to working. So that gives them a little more leverage. It's not clear that that's going to be permanent, right? But secondly, what this source also tells us is that this decline, right, in strikes is due mainly to legal restrictions, not external economic factors. And it talks about here how, yes, there's been globalization, yes, there's been technological change and corporate restructuring, but the real reason that we see strikes going down is because of a crackdown from conservative federal courts, employers, and other sources to effectively try to de-unionize the private sector. So that's a good argument about why, the status quo is not normal. The status quo of low union activity and low strikes is not normal. It's also not a natural outgrowth of the economy. It's as a result of a concerted effort to oppress and to push down unions, right? And so we should be trying to fix it and get back to the prior status quo where strikes were much more common, right? The next point is limits on strikes and the general weakening of collective bargaining hurt workers, right? And here's where we're going to talk about like all the practical utilitarian impacts that restrictions on strikes and the weakening of collective bargaining lead to. And there are a bunch of them, right? So the first one is that limits on strikes and weakening unions generally leads to worsening income inequality and harm to the working class. So this is from Romberg again. This is in 2012. The effects of the anti-union regime are far-reaching. The decline of unionization is a major factor in the rise of American economic inequality, the stagnation of earnings among middle and lower income groups. The system for negotiating the interest at work, the table where the parties might come together to determine their future, has broken down. In its place is a system of management autocracy, largely unaccountable to any actors other than the company's shareholders. The consequences of this regime go well beyond the fate of unionized workers and are damaging for American society, right? So the idea is that the dialogue is broken down because management has become an autocracy. We need to give workers the actual meaningful tools to bring them back to the table and force them to negotiate, right? The next point is that the decline of union bargaining power hurts all workers. This is from Todd Van Hoevelen of the University of Illinois in 2018. And it talks about how weakened unions don't just hurt unionized workers, right? They actually lower wages for all workers, because when unions successfully negotiate better contracts and better compensation, that puts upward pressure on wages, right? And so what he calculates is that non-union workers, right, would have seen a 3 to 7% increase in wage growth during their careers if U.S. labor unions were still as strong as they were before. This is unfortunately a paywalled source, but there's a good summary in Market Watch for those who don't have paywall access. It has some of the money quotes, so you can still get it there. And what it says is the bottom line is that paychecks would probably be bigger and paychecks would probably be more secure and reliable if unions hadn't declined over time for everybody, not just union members. The next point is the decline in union bargaining power hurts public policy and health outcomes. This also comes from Van Hoevelen in 2018. And what it talks about is how unions advocate for their members, but they also have indirect benefits for non-union workers, right? Because they can go out and when they're strong and they're robust and they have lots of membership, right? They can advocate for public policies and programs that affect hours, job security, healthcare, and other things. And what he found is that union decline can explain a quarter of the drop in employees with health insurance between 1983 and 1987, and about 20 to 25% of the decline in pension plans beginning in the 1980s. And this all just goes to the general idea that a world in which unions are neutered, we take away their ability to meaningfully strike, we repress that, right? They become weaker. It's not just their members that are being hurt. They are a force in the market to drive up demand for better wages, to drive up demand for better benefits. And that rising tide eventually can benefit everybody, or at least a large subset of workers. And that's been taken away by neutering the ability to strike and neutering unions in general. There's another point, which is that the unconditional right to strike raises worker wages. This is an actual empirical study from Crampton and others. It's a little old. It's from 1995, but it's an actual empirical study from Canada, right? And it's good because it's a solid, non-anecdotal, systemic study about the impact of allowing the replacement of striking workers versus not allowing the replacement of striking workers. And what it found is when you compare the two, when you do not allow the replacement of striking workers, wages are 10.6% higher, even though strike duration is about 40% longer. And it actually takes into account the lost wages from the strike. And it still says, even with those lost wages, you still have this increase of wages of about 10.6%. This is a nice empirical point that actually looks at, because different jurisdictions in Canada have different rules, it compares a world where you are guaranteed reinstatement versus a world where you're not. And you can say empirically, the world where you are guaranteed reinstatement produces significantly higher wages, right? We actually did an experiment where we looked at different jurisdictions in the same country, and they showed we're going to get a significant increase in wages if we don't have the ability to replace workers, which is a key part of the unconditional right to strike, right? The next point is that strikes raise overall support for the labor movement. This is from Alexander Hurdle Fernandez and others in 2020. This is a good card to show how strikes specifically are linked to the general health of the overall labor union, in that they show non-union workers the leverage that a strike can bring and create overall sympathy for labor, right? And we're seeing how this idea of strikes being contagious plays out right now over the last few years, with a massive increase in the number of strikes among U.S. employers. So what the card says is basically using an original survey in the affected states where teacher strikes were going on, right? We studied the causal effect of strike exposure among parents whose children's ages place them in or out of school. First-hand strike exposure increased parents' support for teachers and for the labor movement, as well as parents' interest in labor action, right? So in addition to this, strikes also make organized labor more appealing by making it more practically effective. A union that can threaten and carry out a robust strike and get concessions from an employer is just going to generate a lot more interest than one that doesn't have any teeth, right? And this is important because I think on the app, you want to make the link between strikes in particular and the overall benefits of unions, right? And if you can argue that strikes generally tend to generate more sympathy and more interest in unions, right? Especially when they're strong and they're robust, then that argument is going to be, this is going to be a contagious thing, right? And we're sort of seeing that right now in the number of strikes that are going on in the United States. Next point is that an unconditional right to strike is essential in the gig economy. So we have more workers than ever that are working in non-traditional, non-employee arrangements like independent contractors. And this is from Gel Visser, I think is how you say it, in 2019. And it just talks about how, especially in the developing world, like in Africa, as well as in parts of South America and things like that, you have huge numbers of employees that are not traditional employees, right? They are gig workers. They are part-time independent contractor type workers, right? And the basic idea here, as we talked about earlier, is that right now, the right to strike is conditioned upon being an employee, right? In fact, the NLRA explicitly says that independent contractors are not protected in their right to strike. You have no right to strike. You can be immediately fired and let go and never hired again, right? So if we're going to protect the interests of these folks, one of the most basic things we have to do is we have to look at expanding the right to strike to include people like, for example, Uber and Lyft drivers, right? I think this is pretty important, right? We might say that Uber and Lyft drivers are independent contractors, but they're really much more like employees, right? They do the same thing over and over again. They don't get to decide how they do it, right? They're told specifically how to do their job by Uber and Lyft. And for people who do that and do other forms of like the gig economy, they can't advocate for themselves through striking under the status quo in most countries. So what we need is an unconditional right that applies to all workers, not just to employees, right? So that's an interesting angle that focuses more on workers than it does on unconditional. There are a few more brief points to address that we really don't have time to cover in depth, but I'm going to list them and put some links in the notes if you want to explore them further. The first is the idea that the right to strike is a fundamental human right. This is from the piece from Jorge Andres Garcia earlier. No real time to cover it, but if you're interested in making a human rights related argument, this piece does summarize a lot of solid reasoning from cases before various international tribunals. The next point would be right to strike is required by international law. There's a piece from James Brudney called The Right to Strike as Customary International Law. Again, not enough time, but if you want to use an international law angle that says, we have to comply with our obligations, I don't know how strong that really is, but if you did, this is a good piece. So that's what we've got in the AF. Let's take a 5-second break and then jump over and look at the arguments on the negative. Okay, so last but not least, at least before final thoughts, arguments on the negative. I was actually pleasantly surprised with how strong some of the arguments on the negative were. I think a lot of the literature is kind of reflexively, pro-labor and pro-union. You can understand why it's a sympathetic cause, but there are strong arguments on both sides here. So let's again just kind of get started with some of the more generic arguments and then move into what I would consider to be sort of more specific arguments, particularly about like specific conditions that the neg can advocate for and try to win on the idea of this particular condition makes the right non-unconditional, right? So the first point is that labor isn't always right. In other words, labor interests and union interests and striking workers' interests sometimes are wrong or mistaken or might be harmful, right? Again, labor interests are often sympathetic, but to win on an unconditional right, the AF needs to show that they are always or nearly always on the right side of the policy question, and that's just not true. So the idea here is not necessarily to convincingly win the idea that, labor interests or striking workers are always wrong. It's really more about like at least fighting to a draw on that question, like fighting to a close question where it's not clear to the judge, or alternatively, make the issue of whether to strengthen unions and strike rights into sort of a case-by-case practical questions. Sometimes it's good, sometimes it's bad, sometimes it's helpful, sometimes it's harmful, and then argue to the judge, well, if it's a case-by-case thing, you can't argue that there is this moral imperative that any just government has to do it, right? So let's look at some examples of when labor is arguably wrong. One interesting kind of visceral example, just to kind of start off on a fun note, is anti-vaccination strikes. So just this past month, we saw labor unions engaging in strikes in places like Italy to oppose vaccination and testing mandates for workers. And you can see the text here. The basic idea is that vaccine mandates have saved tons of lives around the world. They've proven very effective at reducing COVID transmission rates, but you have workers who just don't want to do them, using labor strikes as a mechanism to oppose them, slowing down ports, not working at ports and things like that. And the argument would be, why in the world would we ever want to necessarily encourage a practice that can, in some cases, be as harmful as opposing a vaccination mandate, if you think your judge would buy that. Maybe you're in a place where they don't like those. But that's just one kind of visceral current example of how strikes aren't always right. Strikes get it wrong too. If we want to get more into the sort of traditional economic stuff, right, though there are plenty of authors out there who are happy to write about it. Granted, a lot of these are, from sort of groups that are a little bit biased. They lean to the right in terms of economics, but let's be fair, a lot of our sources on the app lean to the left. So, you take what you can get, right? So one argument on this would be unions reduce jobs and hurt other workers. And this is from George Reisman of the Mises Institute of 2014. And basically what he says is that unions are, essentially cartels that are designed to force employers to do business with their members. And this might be very good for their members, or it might not, but it's often bad for non-members, right? So for example, unions tend to support rules that require union membership to work, like closed shop laws. They also support measures like strict apprenticeship requirements that create barriers to entry. These might allow union members to make better wages, but they also make these jobs harder to get. And they tend to reduce the total number of positions available by making it just more expensive to hire these folks. So if you're not one of the lucky insiders in the union, it might be that you lose out on having any job at all. And so the argument would be that making unions stronger, giving them more leverage, this totally unfettered right to engage in coercive strikes, would only accelerate this process. And at best, it is not a win-win proposition. It is a win-lose proposition. The workers on the inside of the union benefit, but the workers on the outside might not. The next point is that free markets help workers more than unions. This is from Professor Richard Epstein, various places, University of Chicago, NYU. He's with the Hoover Institute. And he basically says that actually weaker unions are good for employment. And he points out how, the decline of union power is good news, not bad. That conclusion is driven not by some insidious effort to stifle the welfare of workers, but by the simple and profound point that the greatest protection of workers lies in a competitive economy that opens up more doors than it closes. And then he goes on to point out that as union membership and strength have declined in the United States over the last few decades, actually employment has grown. And you can see here in some of the text, he just talks about how, you've seen significant job growth in periods of time when you had presidents in office that were less labor friendly, and overall as labor membership has gone down, right? And you've seen unemployment, particularly for Hispanic and African American employees, dropping to historically low levels. So the idea would be that unions haven't done these groups of people any favors. As unions have gotten weaker, unemployment for workers, and particularly for workers of color, has actually gone down. So why should we, again, want to strengthen unions? The next point is that union strength doesn't correlate with income inequality. And this is, again, the same thing from Richard Epstein. And he talks about how, as unions have gotten weaker, you have not seen any increase in the share of income going to the top 10%. They just don't correlate with each other. So over time, you can make arguments about wealth inequality, but the truth is wealth inequality has just not correlated. You can't map one to the other, right? On the history of the United States, at least, right? The next point is that unions hurt consumers. This is from James Shirk at the Heritage Foundation in 2009. And he has a number of points that we're going to look to. But one of the basic things he talks about is, again, a union is a cartel. It's designed to drive up the price of labor, right? So he says, think about it like OPEC. OPEC, the Organization of Petroleum Exporting Companies, one of the most hated cartels out there that raises the price of gas by restricting the supply, right? And he just explains that companies pass on these higher wages to consumers through higher prices, and they also earn lower prices. Economic research finds that unions benefit their members but hurt consumers generally, and especially workers who are denied job opportunities. So again, it's not a win-win, it's a win-lose, right? Some people win and some people lose when unions are stronger. Another interesting refutation he has is that unions don't cause higher wages, they simply correlate with them. This is an interesting block from Shirk. He points out that there's a lot of evidence that unions do tend to see workers have higher wages, right? But what he points out is that correlation doesn't imply causation. And he says, if you control for a lot of factors like age and education, the average worker in Silicon Valley earns more than the average worker in Memphis. But moving every worker in Memphis to Silicon Valley would not raise his or her wages. Workers in Silicon Valley earn more than elsewhere because they have specialized skills and work for high-paying technology companies, not because they pick the right place to live, right? Similarly, it's not necessarily unions that raise wages. They may simply organize workers who would naturally earn higher wages anyway. In other words, if you have the leverage to get recognized as a union and to bring the company to the bargaining table, that may imply that you had skills and abilities, right, that were more rare. In other words, the company decided they couldn't do without you, so they decided they would accept your union, right? So it may be more about that unions are not actually causing increases in pay. They are simply workers who already had a strong hand anyway, right, choose to join unions. Unions reduce future investment in economic growth. Again, from Shirk, this is just empirical stuff about how unions tend to reduce capital investment by 6% or 7%. In other cases, Another study found that unions reduce R&D activity by 15 to 20%. So the idea here is that you want your companies to be investing in R&D so that they can be competitive in the future with your competitor countries and not fall behind, right? And the takeaway from these and other arguments about unions is that a just government applying like a utilitarian framework, what's best for most of our people, might not necessarily want unions to get stronger, might not necessarily want them to have a more robust or unlimited right to strike, right? Depending on the circumstances, a country justly might say, look, right now we need to prioritize investment and growing the number of jobs and lowering consumer prices, right? We need to fight our way out of poverty and have as many people have some kind of job rather than just a few higher wage jobs, so that we can keep up with our neighbors, we can have people who have something to eat, right? A developing country might very well look at that situation and say, look, a stronger right to strike is unfortunately going to slow down our growth, and right now what we need is growth. We need to grow and we need to keep our people fed, and maybe one day we can strengthen unions, but now is not the time. And if at the end of the round, right, it becomes a practical question that turns on the specific data that a country is facing, right? In other words, there may be times when you want to turn on growth and turn on R&D, and there may be times when you want to strengthen workers through unions and a stronger right to strike. If it is a practical question, then it's very difficult to recognize a categorical rule that a just government must always go in the pro-union direction. Now, to turn to what I think is probably the stronger argument, what we've talked about so far there was really more sort of defensive in nature, again, as I said, fighting to a draw. I think the much stronger argument in the negative is to point to reasonable conditions and saying, look, there are conditions on every right. Right. And there certainly are conditions that it should apply to the right to strike. And if I can show you that this should be a conditional right, not unconditional, then I win. Right. And the best way to kick this off is the idea that even unions agree that the right to strike should have conditions. So the International Trade Union Confederation, the ITUC, in 2014, issued a statement on this. And the ITUC is a huge international organization that represents over 200 million workers in 163 countries. And here's what it said about the right to strike. And this is good language. Between the extremes of an unconditional right to strike and an absolute prohibition on strikes in accordance with national law, the international community is converging on the general principle of the right to strike within reasonable limits. What limits are reasonable? The ILO is best placed in most appropriate form to articulate such limits. It is the specialized agency of the United Nations and the entity charged by the international community with promoting recognition of the principle of freedom of association. So the ILO is a UN agency. You've got this International Trade Confederation, a huge union, saying, look, we of course agree that there has to be reasonable conditions on the right to strike. It calls the unconditional right to strike an extreme, and it says that we ought to be looking to specifically the United Nations and the ILO to set these conditions. You should say that's game, set, match. Even unions recognize that this has to be conditional. But of course, you need to explain what the conditions are. And so really the rest of the negative is going to be talking about what are some conditions that could justifiably be part of the right to strike. So let's just start going through them, right? So the right to strike should be conditioned on not undermining union bargaining power. So wildcat strikes are going to be strikes by groups of individuals who are not organized into a union, right? And the basic argument here is that if you've organized a union in the workplace and then other people want to come in and call a strike, that doesn't help workers. That actually undermines their bargaining power, right, which is necessary to achieve all of the impacts the app wants. So this is a turn on all the app impacts, right? The basic reason why is simple. As a union, your basic bargaining chip is if you as the employer don't meet our demands, there's going to be a strike. But if you do meet our demands, then work will go on as usual. But if you have people out there going on wildcat strikes, striking on their own, well, your ability as the union to promise that the workers will show up, right? That is the carrot to go with your stick, right? That goes away, or at least it's diminished, right? So the employer's ability, the desire to bargain with you will likewise be diminished. Why should I make concessions to you, union president, if you can't even deliver all the workers in the plant? And this is supported in a couple of cases in the case law from the Supreme Court in Emporium Capwell Company versus Western Edition, right? And it talks here, as you can see in the quote here, while a union cannot lawfully bargain for the establishment or continuation of discriminatory practices, it has a legitimate interest in presenting a united front on this as on other issues and in not seeing its strength dissipated and its stature denigrated by subgroups within the unit separately pursuing what they see as separate interests. The D.C. Circuit Court of Appeals, which is generally regarded as the second highest court in the country, pointed out, again here in this quote, that wildcat strikes interfere with an elected union's exclusive representation and undermine their authority. The impact, again, is a complete impact turn on the AF, in which we say that if you don't have a condition that bars wildcat strikes and we allow just anybody to go strike when the workers at the employer have voted on a union, that undermines the union because the union can no longer claim the exclusive collective ability to bargain for workers. So that's a really easy condition to win on, and it lets you turn all the impacts of the AF. So I really like that. The next one is right to strike should be conditioned on nonviolence. This is pretty obvious. But the truth is, it's a real concern. It's not like a hypothetical debate concern. Violence, unfortunately, has long been associated with labor strikes in the United States and around the world. To be fair, historically, violence was much more likely to be used against striking workers than by striking workers, but sometimes striking workers have used it, right? So under the NLRA and the Taft-Hartley Act and virtually all labor laws in all countries, violent tactics are illegal, right? And the neg here simply argues they should stay illegal and that this condition on the right to strike by itself wins the round. Now, as we said earlier, AF is going to argue that violence is not part of the right to strike. Violence was never included in the right to strike, so it does not need to be excluded from the right to strike. But what we're going to say is the AF is we're going to say, no, historically, violence is absolutely linked to the ability to strike. It happens all the time. You can't pretend that it's not a part of striking when there's so much historical striking that has involved a degree of violence. You can look back to, for example, December 1894 with a Pennsylvania mine strike, where a group called the Molly Maguires of Irish miners went out on strike and used violence against operators and foremen, and 20 of them were actually sentenced to death for it. That's an extreme example, but even in the modern era, we have, like, for example, this from Alan Farnham with ABC News on criminal charges against union organizers in the Buffalo area, right? And you have allegations that they were stabbing the construction company president in the neck, throwing hot coffee on non-union workers, pouring sand into the gas tanks, threatening sexual assault against the wife of a company representative. And these people were actually indicted by a court, right? Another source on this is Mlungisi Tenza, I think is how you say it, from the University of KwaZulu-Natal. And what they talk about is how there's a frequent use of violent strikes in South Africa. So this is a real intangible problem. And the basic argument that you make as the neg is, of course, we want to ban violence. It has been a part of strikes in the past, and we need to have rules that prevent it, right? And if you can win that definition, that is a condition, then that should be a pretty easy route to the ballot, right? The next one is that the right to strike should be conditioned on workers following basic laws related to public safety and order. And this is a source from Morgan Reynolds of the Foundation for Economic Education in 1983 that talks about how there are certain laws in the United States that exempt striking workers and labor unions from basic prohibitions on things like trespassing, vandalism, harassment, things along those lines. And we just shouldn't be doing that, right? Again, this is just kind of a corollary of the rule against violence. But if you are actively going out and breaking the law, trespassing, if you are harassing people, if you are spying on people, whatever, any general violation of the law, you shouldn't be able to do that as part of a strike, right? So that's a corollary kind of the violence argument. Another argument is that the right to strike should be conditioned on not disrupting essential services. One extremely viable strategy for the neg is to just take the position that the right to strike should be conditioned on not interfering with a country's ability to respond to acute needs and emergencies. And you can focus on one specific case, or you can list several and essentially tell the judge if you agree with any of these, you should vote neg, right? And this can either apply to a specific occupation, like certain professions that provide emergency services, or it can apply more generally to strikes involving certain types of workers during emergencies. So let's start with that latter option, the idea that there should be no strikes during declared emergencies. Even international labor groups, here again, even international labor groups agree that in emergencies, strikes by essential workers should be prohibited. So the International Labor Organization, this again is the UN agency that enforces international labor standards, right? It produces a summary of its decisions. And here's what it has to say about national emergencies: cases in which strikes may be restricted or even prohibited, and compensatory guarantees. And it says a general prohibition of strikes can only be justified in the event of an acute national emergency for a limited period of time, and that some non-governmental organization should decide when that is. Fair enough. It doesn't have to be any specific condition. It can be any condition. And what we're seeing here is that the UN itself, the major regulatory body for labor, agrees in its opinions, right, that when we have a national emergency, right, we should be able to restrict the ability to strike. In the United States, the Taft-Hartley Act allows for exactly this type of suspension of the right to strike during a national emergency. And you can explain why this is necessary in common sense terms. Imagine healthcare workers go on strike at the height of the COVID epidemic. Imagine EMTs and rescue workers go on strike after a hurricane or another natural disaster. Imagine road crews or electrical line workers go on strike after a massive blizzard. Imagine factory workers who are making tanks and planes go on strike at the height of World War II. Well, nobody's going to force them to work, but the idea that we can't replace them, right, that we can't go out and immediately replace them, or that we have to let them come back to their jobs, seems a little bit ridiculous. Now, if you want to look at specific professions, I think probably the single best one is going to be to look at healthcare workers. There's a really good piece from Ramesh Acharya, I believe, who's a physician and professor at the Tribhuvan Teaching Hospital. This is from 2016, and it just talks about how, empirics about the harms from medical strikes, which go on, in other countries around the world, and how this violates the most basic obligations that physicians have, right? And how, in theory, a doctor's profession is different from others, right? In the sense that they shouldn't be primarily about making money, but rather about saving lives. And you can argue, that physicians and doctors make a lot of money anyway. So physician strikes really, should never happen, especially when they're going to cost lives. There are other options. You can look at other professions like the military, police, teacher strikes, things like that. I don't know that they're as strong as medical personnel. I don't know they're as strong as the general idea of no strikes during a national emergency, but there certainly are a lot of options there, right? A bit of a curveball condition that you could run is the idea that the right to strike should be conditioned on non-racist goals. So if you want to have an anti-racist angle, if you don't want to be solely on the downside of that, when you're on the negative, unfortunately, in the history of labor, there have been a number of cases in which racism has reared its head. White workers have opposed bringing in, for example, immigrant laborers as well as black laborers, and sometimes this has even spilled over into violence. So the Labor Commission on Racial and Economic Justice, which, by the way, is a report prepared, this is from a report prepared by the AFL-CIO itself. That's America's largest labor union. And what it is doing, as you can see in these quotes, is that it's expressly admitting that racism in the past has infected the process of labor strikes. It's resulted in violence. Further, racial bias in labor continues today because, as the commission explains, quote, when the number of good union jobs decline, the competition for those jobs increase and create tensions across racial lines. So the argument you can make here, for example, is that general workplace non-discrimination laws that prohibit racial and other forms of discrimination, they should apply to labor unions and they should apply to strikes. And if a strike is found to have been motivated by racial bias, it should not be protected and the right to return should not be ensured, right? A little bit of a curveball, but the idea of racism infecting strikes and infecting unions is not fiction. It's real. It's something that's happened in the past, and it's something that you could potentially run as a bit of a squirrel argument. And then lastly, there's the idea that an unconditional right to strike will only accelerate automation. So automation offers a quick exit from all of labor demands, right? Cynthia Estlin in the Yale Law Journal in 2018 has this piece that talks about how automation, the kiosks at McDonald's and the self-driving cars and things like that, remove a lot of the costs that come from human labor, right? And later in the piece, she says, other laws increase the cost of employing people in less predictable ways. They're a source of risk. For example, union organizing, strikes, and other activities that are protected by federal law pose risks to firms, and firms pay union avoidance consultants a lot of money to manage those risks. So the idea is the stronger and more robust the right to strike is, the higher the cost goes, the greater the incentive that an employer will have to only accelerate automation. So the argument would be, in the world that existed 100 years ago or even 50 years ago, then really putting the screws to employers through this unconditional right to strike, well, they might have had no choice but to give in to demands because they're going to have to pay somebody. But in a world where they may not have to pay anybody, in other words, they may be able to replace you with a robot or a kiosk or a self-driving car, it is not at all obvious, right, that the outcome here will be favorable. So with that is the negative. Again, I thought there were some stronger arguments than I initially believed. Hopefully they'll be useful to you. Let's come back really quickly with some final thoughts. All right, so final thoughts. As you can see, there's a lot to cover on this topic. We barely even scratched the surface in well over an hour. A lot of avenues to attack, but at the end of the day, I really do think that the best cases are probably going to be some of the simplest, right? And so on the affirmative, this so-called right to strike is highly conditional. It's highly unpredictable. Workers don't know when they're protected, and they're denied effective bargaining tools, while their employers can be basically as harsh as they want to be. So what we're going to do here, Judge, is very simple. We're going to make it unconditional. You're going to level the playing field, which lets workers achieve a better life. It's fair. It achieves better outcomes. We're not talking about violence or law breaking because those are not intrinsically part of a right to strike. We don't have to make conditions for them because they were never part of the right to begin with, right? And that's the basic case, right? On the negative, you argue very simply no right is unconditional, right? Here are several good options for conditions, any one of which should win it for the nag. And by the way, as a general matter, it's not at all clear that you want to generally strengthen the right to strike or unions because their results are a mixed bag. They win for some people and they lose for others, right? At the end of the day, though, all I would say is don't lose the forest for the trees. Make sure you're telling a clear, coherent story. Make sure you understand more than you say. You don't walk into rounds where you've just written your case in like 2 blocks and that's it. The more you understand that you actually maybe don't say in the round, the more knowledgeable you're going to seem, right? That background knowledge is going to help you. And anyway, I hope you guys have a fantastic November and December. I hope that you do, as we said earlier, get back to some live in-person debating. But even if you don't, debate is a wonderful activity. So just keep chugging right along as we near the midpoint in the year. And we will see you again in January for whatever the NSDA sends our way. And so until then, as always, we will sign off with, remember, debate is for everybody. So work hard, have fun, and hail state.